was just having a discussion with one of the attorneys on my team, and I felt like the subject that she and I discussed is very pertinent for a video, and that has to do with psychological information and what's shared to the school, so that you as a parent understand what it is that you're handing over to the school, or what it is that you should or should not be saying if a school is paying for a psychological evaluation. Understand that some of this material that you would be discussing in a psychological evaluation with regards to the family history, I think a lot of parents naturally, when they're talking to a psychologist, a medical doctor, to a lawyer, to a priest, for example, that all of this stuff is confidential. It is. Two of the areas, absolutely. I mean, as far as precedent over time, your communications with your attorney outside of the things that you might do to destroy confidentiality is safe. Okay. Same thing with a priest or a minister. There's confidentiality there. At the same time, there are ways and mechanisms for things to be secured from your medical doctors and through your psychiatrist, psychologist, things of that nature. Now, as it relates to your child's school file, obviously they can't go after your personal records, but as it relates to your child, there is a lot of argument that's been made over the years in the cases I've been involved in as to what is relevant academic or educational information. And I've had schools argue these points to judges in the attempt to get subpoenas to be able to acquire this information. And then, of course, I would come in and I would attempt to block it, making the argument that they're only entitled to what would be educationally relevant. But in the world of special education, when we have categories like emotional disability and ADHD and autism and some of the things that go into and reach into other educational performance areas, meaning educational performance areas like social emotional development that includes behavior, then there's arguments that can be made that we as a school, as an IEP team, need access to greater information to understand, what we should or should not be doing. Well, the devil's in the details there. I don't necessarily disagree with that. At the same time, there is a lot of information that families will volunteer in an attempt to have the psychological or psychiatric professionals understand the historical nature of things. At the same time, guys, a lot of that information then could potentially be turned over to the school. And if you're voluntarily providing this information unredacted, meaning that you're not redacting some of this very personal information that might not have anything to do with your child. It's just a family history of, let's say, psychological concerns, either on the paternal or maternal side, even on the grandparent side. Some of this information being shared and not redacted can be accessible to very human beings that aren't good people, okay? And you sit there and you say, well, my kids' records, they're private because of FERPA. FERPA is a nonsense BS, no teeth law, guys. It is a government facade to make people think that somehow there's student privacy for your records. And, I'd have to say it's about 65% effective, meaning that the schools aren't sitting there peppering the earth with your child's information. At the same time, internal employees, this stuff isn't safeguarded like you think it would be. And the other thing is human beings talk, human beings gossip, human beings that don't like you can gather information, share it. It is almost impossible to sit there and point the finger at who did it. It's impossible to sit there and claim retaliation. It's all of these things to safeguard your child's records. These are things that take time, and it is some forethought. And especially if the school pays for the evaluation, guys, at that point, you need to be very guarded in the information that you share, sufficiently to where the psychologist or the psychiatrist can do their job, but at the same time, with the understanding that this information is going to go to the school system who paid for this evaluation unredacted. And if you somehow think that these individuals magically are going to, be good, enlightened, righteous individuals, then you're deluding yourself. Most are, some are not. And it could be you're working with a great staff this year. What about next year? What about 5 years from now? This information is in the child's file. And this stuff tends to become a potential problem. And it's stuff that you can avoid and stuff that you can stop with some preparation and some forethought. Okay? If it's evaluations that you are paying for through your insurance, then at that point, any consent that you're giving to the school to be able to access your children's record, guys, HIPAA is a one-way street. You can go to your provider and you can put into the notes, into your child's file notes, that any consent that you give into the school is for educationally relevant material. And you can sit there and say X, Y, and Z needs to be redacted before handing that over. And this is something to where you need to work with your private provider, if you paid for these reports, to specify and determine what is educationally relevant information to share. Other information they should guard and keep safe under HIPAA. HIPAA does come with far more power because there are consequences, and I'm talking fiduciary consequences and consequences to licensure if they violate HIPAA. There is no punishment if schools violate FERPA. It's this. You see that? Don't do that again. But there is no far-reaching consequence like there is for HIPAA. Guard yourself. This is how you do it. Okay?